Good afternoon, Ms. Mthalane. Please switch on your mic in front of you.
Good afternoon, CJ.
How are you this afternoon?
I'm well, thank you.
Okay, thank you very much for availing yourself for this interview. We appreciate it. I'm going to ask you questions, and commissioners will ask you questions as well. The whole purpose of our questions is to see how you meet or satisfy the selection criteria that this body has adopted for the selection of judges. We may be robust in our questions, but no one will be intending to humiliate you or demean you in any way. All we'll be doing is just to try and satisfy ourselves how you meet or satisfy the selection criteria. You understand?
I understand.
Yes. You hold an LLB degree, is that correct?
Correct.
It's a 4-year LLB degree.
Correct.
It's the 4-year one. Okay. Which you obtained in 2006, is that right?
Correct.
From VETS. You got it from the University of Witwatersrand?
Correct, CJ.
Yes. You served articles at Mkabela Huntley Attorneys, is that right?
Correct.
You were admitted as an attorney in 2008?
In 2009, January.
2009. Okay. And then you went then to be an associate at Cohen Harper Attorneys from 2009 to 2011. And then you were in Mabaso Attorneys from 2011 to 2013, is that right?
Correct.
And from 2013 to 2017, you were at Solomon Holmes Attorneys, is that right?
Correct.
And in 20, you stopped working for Solomon's Homes in 2020, December, is that right?
Correct.
And then you became a director at Lawton's Africa, is that right?
Correct.
In January 2021. And it went up to 2023. Is that correct?
2022.
2022.
Oh, my apologies, CJ. 2023, February, correct.
Okay. Then at the moment you are not in practice. You are a group ER manager at PepsiCo. Is that right?
Correct, CJ.
What is ER manager?
Employee Relations Manager.
Oh, okay. So you started in 2023.
Correct.
I seem to detect a pattern here. From the time you were at Cohen Harper Attorneys as an associate up to now, you appear to stay only about two or 3 years in a place and leave and go for employment elsewhere. You see, you say here, from July 2009 to December 2011, you were an associate at Cohen Harper Attorneys. And then from January 2011 to February 2013, that's more or less 2 years, you were at Mabaso Attorneys. Then June 2013 to December 2017, that's about, 2.5 years, you were at Solomon Holmes Attorneys as a senior associate. And then from January 2018 to December 2020, you were at Solomon's as a director. So you were at Solomon's You had Solomon's from 2013. Oh, no, it wasn't 2 years. It was 2 years in a particular position. From 2013 to December 2020, you were in the same place. Is that right?
Correct.
But the one relating to Cohen Harper, I'm right, from July 2009 to December 2011, that's about, is it about 2 years? You were an associated Cohen Harper. And then at Mabaso Tennis, also you were there for about 2 years or a year and a half, I'm not sure. At Solomon Homes, you stayed at least from June 2013 to February 2023, to December 2020. And that's about maybe 7 years, 6 years. And then you went to Lawton's Africa as a director, January 2021, and then you left in February 2023. And then you went to PepsiCo. So at Lawton's, you stayed for also about 1.5 years or 2 years, for about 2 years, January 2021 to February 2023. At PepsiCo, you arrived in March 2023, but you now want to leave to go to the labor court.
Correct.
That doesn't give one the picture of somebody who is stable. That gives the picture of somebody who is always looking for a better deal and will stay for a short time and then move.
I understand, CJ, why and how it appears so. However, there's an explanation for every move. The firms that I've worked for have all represented different interests and different parties. For an example, I will start with Nkabela Hanshi, that represented largely state-owned entities. And I wanted to move and do work for the corporate sector. Hence, I took the offer at Cohen Harper. And at Cohen Harper, I met Mr. Sandile Mbaso. I worked a lot against him. He represented unions, and he recruited me. And at the time, I also wanted to get a feel and experience of working for the employees and working with the unions. And I then moved to Mabaso Attorneys. And then I was recruited by Solomon Homes. And the reason why I joined Solomon Homes is because they offered me directorship and partnership. So they offered me a room to grow and to experience practice and running a business. It's also an employment law boutique firm. Therefore, I joined Solomon Homes for those reasons, and I gained a lot of experience as a director and partner. However, because it's solely practiced in employment law, it was a challenge getting clients. Whereas at Lawton's, what they had, because they practice in different areas of law, I was able to tap into their clients in order to get work. And the reason why I joined PepsiCo is because practice, being an equity partner and a director, it just became challenging for me. And at the time, I was pregnant, and I wanted to be in an environment that was enabling, to enable me to care for my child, at least for those first couple of months into maternity leave.
Well, I didn't think that you would have left without having a reason to leave. Obviously, you would have some reason to leave. But It just seems to me to be too often. I mean, at PepsiCo, you arrived in March.
Correct.
At PepsiCo, you arrived in March this year.
Correct.
So in June, you were filling the form to send here already. They were still greeting you there. They were still greeting you.
I made it clear in my interview, and they are even aware that I am here today. I made it clear that my ambition was always to ascend to the bench. Hence, I stayed and served in practice for a very long time.
But if your ambition is to go to the bench, isn't the best way to remain in practice? Why do you leave practice if your ambition is to go to the bench? It seems to be to want to do one thing but do something that is the opposite.
Not so, CJ. My personal circumstances dictated that I take a break. It was not a permanent thing that I take a break from practice. It is quite challenging to be a partner, a director, a manager, a marketer, a marketing officer all at once in practice.
Do you know the workload in the labor court?
I'm very much aware, CJ.
Can you handle that?
It's not the workload that I'm afraid of.
What are you afraid of?
It's performing different functions at once. And at the time, as I said, I was looking for an environment that was enabling, as I had just given birth and I had a little child who is now 7 months old. Therefore, in practice, as a partner, you're not only just an equity partner, you are a director, you are a marketer, you are a manager, you train. But in the labor court, the work is more structured in the judiciary. If I may put it like that, you have one client, which is the public sector. There's no obligation on you to go out there and hunt for clients. You already have that. And all you need to do is your work. That's not how practice works.
Yeah. I see that in terms of actual practice, have you done any cases on your own, conducted trials?
I do all my motion proceedings, well, 80% of them, on my own. Trials, I would then instruct counsel, but motion proceedings, I do them on my own. I don't really instruct counsel in those matters.
And have you been appearing in the labor court a lot?
Yes, when I was in practice, I used to appear in the labor court quite a lot.
Mm-hmm. For motion courts?
Correct.
I see that at paginated for page 9, where you were asked to give a proportion of your work, what proportion of your litigation work has been in the field of criminal law, you say none.
Correct.
Administrative law, you say none. Consular law, you say none. Labor law, 100%. And it says other areas of civil law, you say none. Is that correct?
Correct, CJ. I've worked since I started my articles, I've always worked in employment law firms.
But it must be a disadvantage to you compared to other candidates if you really, all you know is just labor. You have not done anything else. Because when you sit as a judge there, it might be labor court, but principles that apply in other branches of law sometimes come up. And for example, here, administrative law, you said none. Some administrative law cases are dealt with in the labor court. So how are you going to handle those?
Correct, CJ. Or perhaps what I should have said is that I have done, for an example, constitutional law and administrative law on a limited basis, but insofar as it pertains to employment law matters.
Yeah, well, you were not asked here to give a proportion of various areas of labor law. You were asked
Correct, yes.
to indicate, it said what proportion of your litigation work has been in the field of, and then they give you all those fields. I mean, you must have an idea of how criminal trials get dealt with.
Most definitely.
You must have an idea how civil trials get dealt
Correct.
with. And so on.
Most definitely, CJ. It's not just an idea. I mean, I've done some in
But
practice,
your
not
questionnaire
much.
doesn't say that. Your questionnaire says none. The whole idea of this question is to give you an opportunity to share with the commissioners the breadth of your knowledge in terms of practice. What experience has your practice given you in the various fields? That's the purpose. That's why they say give a percentage. And your answer is none. And then when it comes to labor law, 100%. Are you saying that's not, it doesn't reflect the true position?
CJ, it doesn't reflect the true position, and I suppose I did not really think about it. Because, I mean, as a lawyer and an experienced lawyer with over 15 years of experience, I have worked on some constitutional matters, some administrative matters, but then again, within the context of employment law.
Yes. Page 12 says, 6.4, list all the reported cases in which you appeared as instructing attorney, and you have listed one. Is that right?
Correct. Yes.
But also that case, you have not shown that it is reported. The information you put there is information of an unreported case. Can you see that? The question asked you to give a list of reported cases in which you appeared as instructing attorney, and you gave a case, an unreported case.
Yes, I see that, CJ. CJ, as far as I can recall, this case is reported.
Yeah, but it doesn't help for you to not to reflect that in the questionnaire, because the question clearly says list reported cases. You understand? In the questionnaire, you are supposed to give us information that will help us assess whether we should recommend that you be appointed.
Of course.
If it says give us reported cases, and maybe you do have a reported case or reported cases, but you choose not to give us those, you give us something else, that creates difficulty, doesn't it?
It does.
So what would be the explanation for you for having given us information that reflected that the case is unreported, if in fact it is reported?
CJ, I'm looking at paragraph 6.4, right? Mm-hmm. Which provides list all the reported cases in which you appeared as instructing attorney.
Yes.
And then I go on and I list that case.
Yes, but it says reported cases.
Correct.
And you don't give information that reflects that this case is reported.
But, okay, now I understand. I'm with you. Okay.
Have you acted in the labor court?
Yes, I have.
For how long?
I acted for a week in January 2020, and again for a week in 2021, and I acted for a term in 2023.
Okay. Did you sit in motion court matters?
Yes, I did.
And did you do trials?
Yes, I did.
Okay. Did you give judgments on review matters?
Yes, I did, CJ.
What can you tell the commissioners about challenges relating to Section 157, giving the Labour Court and the High Court concurrent jurisdiction in certain matters?
Previously, the challenges were that litigants would, especially in the public sector, would often avoid the labor court by running to the high court and bringing their matters within, or couching their matters within PAJA. And since the case of Chira, that conduct has, we've seen a deterrence in that conduct because Chira, in support of Section 157, has said that employment law matters fall within the jurisdiction of the labor court. And the labor court has concurrent jurisdiction with the High Court in matters that involve a constitutional issue. So those were the challenges before, but we have seen in practice that there has been a deterrent of litigants from approaching the High Court if a matter involves an employment law dispute.
If you are appointed to the Labour Court, you may be called upon to, or you will be called upon to preside in trials. Are you able to share with the commissioners what the requirements are that must be satisfied before you can draw an inference in a civil matter?
Yes, CJ. So an inference will be drawn on an inference will be drawn on a proven fact. If that is the only inference to be, sorry, let me just correct myself. So an inference will be drawn in circumstances where the only inference to be now I have a mind block. Okay. If there's no other reasonable, it will be drawn from proven facts. And if those proven facts, there is no other reasonable inference to be drawn, but the inference that is sought to be drawn.
Remember, I said in a civil matter.
Yes, CJ, in a civil matter. There must be.
You know, the requirements are not the same if it's a criminal matter and if it's a civil matter. There's some difference. You appreciate that?
Correct, CJ.
Okay. So that's your answer for a civil matter?
Correct, CJ.
Okay. What are the requirements for a temporary interdict?
The requirements for a temporary interdict is that there must be a clear right. The applicants must be able to demonstrate a clear right, and the applicants must be able to demonstrate a reasonable apprehension of irreparable harm, and the applicants must demonstrate a balance of convenience, and of course they must be able to demonstrate urgency.
What are the requirements for a final interdict?
They are the same. It's a clear right, irreparable harm, but for a final interdict, the balance of convenience is not a requirement.
I will now give the opportunity to the Judge President of the Labour Appeal Court, to put questions to you.
Thank you, Chief Justice. Good afternoon. Ms. Mthalane, you were informed about this affidavit which I received in a leave to appeal. You've indicated that you feel it might not be appropriate to deal with that, but I think there's nothing wrong in dealing with the important issues that's raised there.
Okay.
Unless you feel that it's not right, then let us know why, and then. But let me raise those things, what's said in that affidavit, because I think it's very important. It's very important for you to deal with that. And it says in paragraph 5, the application was heard. This is the application you heard.
Correct.
On the 25th of January 2023. And this was the time you were working at Lawton's, but you were
Correct.
acting in the labor court.
Correct.
Right? And the judgment was delivered on the 3rd of March. At the time that the application was heard, Mthalane was, despite the fact that she was acting as a judge of the above honorable court, employed by Lawton's Africa, who are the current attorneys of record for the respondent. Mthalane only left the employ of Lawton's as of February 2023. Is that right?
Correct.
Then they say Mthalane, in fact, represented the respondent in several employment-related matters during her employment with Lawton's, and I personally interacted with her on some of the matters she acted on behalf of the respondent. They go on to say, given her association with Lawton's and the fact that she had numerous interactions with the respondent and knew that the respondent was a client of Lawton's, she ought not to have adjudicated the application. It is contended that Mthalane should have, in fact, recused herself and not adjudicate the application due to the reasons I have set out above. Now, the issue is, this was a client of Lawton's.
Correct.
You knew he was a client of Lawton's.
Correct.
You were an employee of Lawton's.
Correct.
You had interacted with this person before.
Correct.
Didn't you think it was improper to hear that case in which they were involved?
The applicant in that application it's a state-owned entity with a wide panel of attorneys. And at the time, Lawton's was not involved in that matter. Hence, I did not perceive there to be a conflict of interest in that matter. As Lawton's was not involved, they were not on record. We had not even drafted any opinions or advised the client in that particular matter. Hence, at the time, I did not perceive it to be a conflict of interest. However, in hindsight, I do acknowledge that I should have at least alerted the parties to that fact.
Why in hindsight? Why not at the time? Did you tell the parties that this applicant or respondent is a respondent with whom you've had interaction in other matters?
The particular respondent, the deponent to that affidavit, was not involved in that matter as well. Was not at the time.
Maybe not him personally as a person, but the respondent is not an individual. Isn't it the municipality?
Correct.
Yeah.
Yes.
So don't you think you had a duty to inform the parties?
Hence, I'm saying that in hindsight, that is what I ought to have done. That would have been the proper thing to do.
I have difficulty with that, but okay, let's move on. When you completed your questionnaire and you submitted your application, so to speak, you included a certificate of good standing.
Correct.
Now, we know that you left practice at the end of February, is that correct?
That's correct.
You started working for PepsiCo at the beginning of March.
Correct.
At that time, you were no longer in practice.
That's correct.
Did you remove your name from the roll of attorneys?
No, I didn't. I was not aware that I'm supposed to remove my name from the roll.
Did you read the certificate of good standing which you submitted with your application?
Yes, I did.
And what does it say in paragraph 2? It says that her name has not been removed from the roll of attorneys. She has not been suspended from practice. But you were not practicing, isn't it?
No, I was not practicing, but I'm still an attorney.
Sorry?
I'm still an attorney, but I'm not practicing. I was not aware that if you are no longer practicing, In fact, it's only been brought to my attention now. I was not aware that if you are no longer practicing, then you're supposed to inform the Law Society so you could be removed from the role of attorneys. It's my first time becoming aware of this.
And you did remove your name later from them?
I haven't because I was not aware.
Sorry?
I haven't yet because I was not aware. I'm only becoming aware of it today.
But did you remove your name from, or not yet?
Not yet. I was not
Then
aware.
why
until
is it that the Law Society says that she is on the role of non-practicing legal practitioners?
I know I didn't remove my name.
Okay. Let's move on. Tell me, what can you tell me about derivative misconduct?
It's another type of misconduct where if an employer is seeking, which an employer can use when in charging employees who have witnessed the primary misconduct but have failed to disclose or refused to disclose that primary conduct or that to identify the perpetrators of that primary conduct to the employer.
Sorry, can you repeat that? I didn't hear that properly.
Okay, so derivative, it's a type of misconduct which is committed by employees who have knowledge of what we call or refer to as the primary act of misconduct, but who fail to disclose that to the employer.
Is that derivative?
That is derivative misconduct.
What does the Constitutional Court say about derivative misconduct? Do you know?
Yes, the Constitutional Court in Dunlop has said that, in fact, it has done away with derivative misconduct altogether. It said that there's no duty on the employees to disclose the identity of the perpetrators because the employer does not have the same duty. And furthermore, it said that the employer has recourse in that the employer can charge the employees with primary misconduct, and that the employer then should focus itself on that primary misconduct and not derivative misconduct.
You've read this judgment a long time ago, I assume.
No, not long time ago, probably I don't know, last year.
It says more than that. Eh? It says there's no duty on an employee
To
to
disclose.
report unless
Correct.
the employer gives them protection. And the employer has a reciprocal duty. Is that not so?
Correct.
Then, do you remember the case of Edgars and Steenkamp?
Edgars and Steenkamp.
Edgars and Steenkamp, yeah, to do with it's a Constitutional Court judgment dealing with a claim made by the employees when they were retrenched to say the retrenchment was unlawful, and they sought certain relief in terms of the LRA. Do you know what was the...
It was an
judgment?
unfair retrenchment case, and what the employees sought was compensation.
Sorry?
What the employees sought was compensation.
What did the Constitutional Court hold? Do you know?
I don't remember the
What was
findings.
the ratio, you know?
I don't remember the findings of the
You don't
Constitutional
remember
Court
that. The
case.
Constitutional Court says if you bring a case in terms of unlawfulness, you can't claim for relief in terms of the LRA. Do you remember that?
Mm.
Okay. Now, just... I have nothing further. Thank you, Chief Justice.
Thank you. Just a follow-up. Ms. Mthalane, the complaint here is that in January 2023, you had this matter which involved the city of Tshwane, and Tshwane was a client of the law firm in which you were employed at the time.
Correct.
How could you think there was nothing wrong with sitting in a matter involving a client of your employer?
CJ, I had read the file, and at the time, there was no opposition in the file. The matter was unopposed.
Does
And
it
that-
matter?
The matter was unopposed, the Rule 11 application at the time of my
Does it
perusal
matter
of-
that it's unopposed for purposes of the question whether you can sit in the matter? You are employed by Lawton Attorneys.
Correct.
This client, this litigant, is a client of your employer.
Correct.
How can you sit in that matter?
I did not perceive that to be a conflict of interest, CJ, because Lawton's Africa was not involved in that matter.
Yes, but this was their client,
Correct.
and you were still employed by them.
Correct.
You didn't even raise the matter with counsel.
Correct, CJ. Hence, I'm saying in hindsight, I should have raised it with counsel.
Minister?
CJ, I do have a question, but I think I will defer to commissioners in case they ask
Yes.
the question.
Yeah,
If they
okay.
don't, then I will come back.
Okay, all right.
Thank you.
I haven't seen, Commissioner Dudovu.
Thank you very much, CJ. Good afternoon.
Good afternoon.
I want to traverse with you the matter where you presided. That is of Correctional Services versus Mthalane. For me, the allegations about you are very serious. That you refused leave to appeal in chambers without the party's legal representatives being present. Can you speak to that a bit? Can you respond to that particular matter, please?
Commissioner, there may have been a mistake because I was not involved in that matter. I did research and I looked it up, and it wasn't one of my matters.
It means you are not a presiding judge on this particular matter.
Correct.
What the GCB is raising, it is far-fetched. It's not existing.
It's not correct, Commissioner.
Do you understand the repercussions of this in case that it is found that indeed you presided over this particular matter?
I understand, Commissioner. I've done my research, my thorough research, and I can tell you I was not involved in that matter.
Okay, thank you very much. Thank you, CJ.
Thank you. Commissioner Baloyi?
It's not so much, good afternoon. It's not so much a question, but to clear up, to assist clearing up an earlier discussion that you had with the JP. And it's about your being on the roll of attorneys, even after you left practice, that the correct position, in fact, is if you're not in practice, you go on to the non-practicing attorney's role without the requirement that you should remove yourself from the role of attorneys.
Thank you.
That is correct.
Thank you. Commissioners on the virtual platform, I didn't see any indication. I think there is none.
Nothing from my side.
Thank
Nothing,
you.
thank you, Chief Justice.
Thank you. We have come to the end of this interview, Ms. Mthalane. Thank you very much for availing yourself. You are now excused.
Thank you, Commissioner.